Yes, just a quick round of introductions here. Myself, Jennifer Chadband, I am co-manager here of our consulting division with Sazio, and joined by my colleague, co-presenter, Rick Serber. He also is a co-manager here with the division here, and he manages our legal research division as well. And we're very excited to have Brandon joining us today, one of our own. Brandon has been with Sazio for several years now. He started in our legal research division and has gained a lot of experience over the years conducting very specific research for our clients, including a lot of this privacy research that's become so important. Brandon has a JD. He's also a CIPPE certified professional, so certified information privacy professional for the European Union, and he's a licensed attorney as well. So we're happy to bring Brandon on. I think a little bit more in just a quick introduction to the topic before we hand it over to Brandon. You know, as I mentioned, Brandon's got a great deal of experience going through these laws, and there's a lot of it. I think what we hear a lot is that our clients are kind of overwhelmed with, you know, what should I be focusing on? All of these different laws from different jurisdictions. We're thinking about, you know, the US and international, and, you know, even within the US, differences amongst the jurisdictions. States are passing new privacy laws all the time. There's different requirements under all of these laws. And Brandon's going to kind of break those down and help everybody, I think, maybe understand, you know, what are the really important parts of these laws for our program, for our records retention schedule. How does this all come together in some sort of, you know, simplified way as part of that program, part of our policy that we can actually follow for all of these. So really, it starts with the research. And understanding all the different obligations that arise under these different laws that companies are obligated to follow. And so this is really kind of building off of our last privacy webinar. Frank Fazio, also an analyst with Sazio, he really kind of got us up to speed on all these new privacy laws that were passed last year. And now we're kind of getting into the details. How do we break these down? And I'll just kind of let you know too, our next webinar is also on privacy. It's going to be more so about taking these requirements to your schedule, to your policy, and what does that look like? And we did get some questions on that today, so we'll kind of briefly acknowledge those, but just so you know, that's kind of where we're going. So I just wanted to take a chance to kind of introduce the bigger picture on here before I hand it over to Brandon, who's going to get a little bit more into the weeds, but not too much into the weeds on all of these different requirements, because you can certainly spend a lot of time going on them. So with that, I'll go ahead and hand it over to you, Brandon, to kind of get us to started on your presentation and our discussion for today.
Yeah, awesome. Thank you for the introduction, Jen, and thanks everyone for joining us this morning. As Jen had mentioned, I've been with the company for almost 4 years now. I started right when COVID began, and that feels much longer than 4 years ago, but not because of the work. I think just how life has certainly adjusted. But you know, I'm very lucky to be able to find these requirements interesting, but I imagine that most will consider them pressing and not as interesting. My goal for our discussion today is to walk through processes that you can use to simplify and better understand these privacy requirements as they relate to your organization. Given the time constraints and for everyone's sanity, we can't cover every single detail, but I believe that these general principles can be continuously applied to improve your understanding as we see adjustments and new laws passed. This will involve analyzing the applicability of privacy laws as well as reviewing common concepts that we often see. More specifically, we will review regulated parties, personal information definitions, breach notifications, data subject requests, and cross-border transfers. So how we are going to do that is to break down these requirements in a granular fashion. This will require us to identify commonly regulated concepts and discuss common themes that we see around the world, sort these specific categories into smaller subtopics, and compare requirements between jurisdictions. Ultimately, I hope that this approach sparks some ideas that you're able to bring to your organization. But before we dive into the substance today, I wanted to touch on the importance of these topics from a practical perspective. Obviously, successful RIM and privacy programs are compliant, but I think that the million-dollar question is, how does an organization get there? I think that the answer to this is to focus on smaller steps. The first step is identifying and understanding those requirements that relate to your organization. Ultimately, smaller steps allow for smaller wins, which build the momentum in your programs. The survey found that only 18% of employees were totally confident in their company's compliance with privacy laws and policies around the world. For those not so successful RIM and privacy programs, we can see a steep financial burden. Our discussion today won't prevent a breach from occurring. However, damage control can certainly be useful. The average cost of a global breach in 2023 was $4.45 million. The two most common record types involved were customer and employee information. And not only were these the most common, they were also the most expensive. On average, the cost of breach for customer information was $183 per record, and employee information was $181 per record. And finally, not only are we seeing an increase in the number of privacy laws that are passed, but we're also seeing an increase in compliance-related activities for organizations with laws already in existence. Survey found that 60% of respondents reported an increase in data subject access requests over the past year. I anticipate this increase to continue as consumers only become more aware of their rights as it relates to privacy. Ultimately, this leads us with where to begin. So with those somewhat terrifying statistics in mind, we can discuss the first step, which is analyzing the requirements that apply to your organization. I think that the three general questions that you can ask to aid in this determination are: where do we operate and provide services? Who is regulated by the requirements? And what information is governed? Determining where you operate and provide services may allow for you to limit the number of jurisdictions that you have to review so that you really can focus on what applies to your organization. Once you do have this list of jurisdictions compiled, you get the lucky job of diving into these requirements. Now we'll look at some regulated parties and specifically common concepts that we see around the world. In the US, we see that regulated parties can be entirely exempt from state comprehensive privacy laws. Exemptions can be categorized as entity-level exemptions, which exempt entire organizations and come in the form of numerical thresholds, which require conditions that must be met in order for the law to apply, or institutional exemptions, which exempt organizations regulated by specific federal laws, such as the Gramm-Leach-Bliley Act or HIPAA. Alternatively, we see topic-level exemptions, which exempt specific subject matters of information. Common forms of topic-level exemptions that we see are employee and applicant information, as well as information subject to federal laws, such as, again, the Gramm-Leach-Bliley Act, HIPAA, or the Fair Credit Reporting Act. Outside of the US, this is not the same story. Entirely exempt situations rarely apply to commercial activities. Oftentimes, the outright exemptions apply to activities of governmental organizations or those that relate to national security or the freedom of expression and information. This results in the general consumer privacy law, such as the GDPR, applying to a much larger number of organizations. This also exemplifies the patchwork system that we see in place in the US. However, just because your information may be exempt from a state comprehensive privacy law, it does not mean that privacy rights do not exist. It simply means that you're not afforded the same protections that are provided for under the state privacy law. We do see common themes in both comprehensive state privacy laws and federal provisions that allow for the same actions of a data subject. An example of this is HIPAA providing a right of access as well as a right to correct. But again, you often do not get that broad protection or coverage that we often hear about for these state privacy laws. Now we can dig into some specific provisions as they relate to California, Colorado, and the EU. As you can see from the data controller definition column here, there's a broad definition that's used for all jurisdictions. We see some common language of alone or jointly with others determining the purposes and means of processing data. These general definitions are not likely to exclude an organization if you've already considered your operational footprint. However, when we move over to the threshold conditions that we see, it's apparent that these threshold conditions are only commonly used in the US. The three categories of numerical conditions that we typically see from states are revenue, which is based on the revenue of all business activities and not just those related to selling or sharing information, processing, which considers the number of consumers whose data is processed, and sales, which is based on revenue from selling consumer data, often focused on how the percentage of revenue gained by an organization or the number of consumers whose data is sold. States will require that only one threshold must be met in order for the law to apply. However, we commonly see that for the categories of conditions used, most states are opting to only use the processing and sales threshold that we see here in Colorado. The numbers within a specific state largely vary. However, these common categories that we see have been very useful in helping with my understanding of these laws. Moving down to the EU, we can see that these numerical threshold outright exemptions are uncommon internationally. However, organizations should still be aware of numerical conditions that allow for exemptions within a specific article of the law. An example of that is Article 30 of the GDPR, which allows for a general exemption for organizations with less than 250 employees for records that relate to processing activities. Organizations analyzing these requirements should remember that a data controller definition is often broad. It's likely to have little impact if you've already gone through the steps of analyzing your operational footprint. However, keep track of the categories for thresholds in each US state as they relate to your organization. This can allow for a quick analysis of what states should be further reviewed if you determine that the law may apply to you based on these thresholds. And it's an easy to track method as states begin to pass new privacy laws. However, I do have to warn you now that Texas decided to mess up my perfect table that we have that can be used for all states, and that might be a new virtual coffee discussion on its own. Here we have some specifics as they relate to exemptions in these state privacy laws. The list that's included here at the top, nonprofits, institutions subject to, and information subject to, is not an exhaustive list, but I included the exemptions that I find to be the most impactful. The blank boxes here are what would be considered outliers for these specific states. Colorado does not exempt nonprofits, California does not exempt institutions subject to the Gramm-Leach-Bliley Act, and both states do not exempt institutions subject to HIPAA. In mentioning HIPAA, we can see that California only exempts personal health data maintained in compliance with HIPAA, while Colorado exempts all information and data maintained in compliance with HIPAA. And finally, but probably the most impactful, is that we see California does not exempt employee or applicant information. As you can see here, I provided a summary of the specific federal requirements that I've made mention of during my discussion today. We can see that these are topic or organizational specific: Gramm-Leach-Bliley, financial institutions, HIPAA, medical records through insurance companies and medical providers, Fair Credit Reporting Act with consumer credit information. Again, this is only exemplifying the patchwork system that we're seeing in the United States. For an organization considering these requirements here on the screen, it's important to still be mindful of your operational activities in each state, and more specifically, the information that you keep and the purpose for which it is kept. For example, an institution regulated by HIPAA with operations in both California and Colorado will require a somewhat different analysis due to only personal health data being exempt in California, with all information maintained in compliance with HIPAA being exempt in Colorado. Moving over to specifics for exemptions that we see in the GDPR, These exemptions, again, rarely apply to commercial activities. The common situations are those for national security, actions by governmental entities, and other specifics that are provided for, such as Article 23, which allows for restricting data subject rights with a proper basis for things such as judicial independence and national security, or Chapter 9 of the GDPR, which allows for member states to exempt requirements based on the freedom of expression and information. The end result of these exemptions having little to no impact is that the same privacy law covers more entities. You do not have that patchwork system that you often hear about within the United States. We also need to consider regulated party definitions as they relate to breach notification requirements. Luckily, this is a much more straightforward analysis. We can see that within the US, the regulated party term that is used is not a data controller. Instead, general terms are used such as business or person. Numerical thresholds are absent from these US states, and this results in the breach notice law covering a larger number of entities considering the regulated party definition. Internationally, you can see that we are still using the term controller. This is because breach requirements and other consumer rights for privacy laws are provided for and passed under the same body of law. The US has somewhat worked their way through these privacy laws as time has gone on, only adding to the patchwork that we have seen with these topics and simply states trying to catch up with what may be the new norm. For an organization analyzing these provisions, you're not likely to consider activities that are exempt within these jurisdictions, again, if you've already considered operational footprint. These are such general definitions that we see here that that the definition of a regulated party is not likely to exclude your entity or organization. Once you've reviewed regulated parties of privacy laws, you then get the joy of turning to personal information definitions. Some common concepts that we see around the world. Specifically in the US, personal information is defined differently depending on the context. In state privacy laws, we have a broader and more inclusive definition, which results in, again, more general coverage of personal information. This is not the case for breach laws, which requires a specific combination of data elements in order for the information to be deemed personal information. Internationally, we see that personal information, again, is defined the exact same, irrespective of the context. A broad and more inclusive definition is used, which allows for a much simpler analysis for you and I. Here are some specific examples to compare those concepts that we see for personal information definitions of breach notifications and those personal information definitions in comprehensive privacy laws. In the US, we can see that both California and Colorado require a combination of an individual's first name or initial, last name, and one or more specified data elements. Common data elements that states will often include are government-issued ID numbers, medical or insurance information, and financial account information, but only with the security code. However, these lists of data elements greatly vary state by state.
And
moving over
Brandon,
to copy.
Oh, sorry to interrupt you. I thought this might be a good point for some great pre-submitted questions. And I just wanted to mention, you're talking about some of how encryption impacts, some of these breach notifications. And we had some really good pre-submitted questions about encryption, de-identification, and internal sharing of personal information that got into the weeds and were just a little bit outside of the scope of this webinar. I promise we're not ignoring any of you, but they'll fit better with our next privacy continuation webinar in March. So keeping it high level, I'll just say that encryption and de-identification, kind of like it's shown in Brandon's slides here, it changes the rules for most jurisdictions, often taking information out of what's regulated. So essentially, if done properly, it may not even be relevant to the rules about breaches if it's de-identified, encrypted, and so forth. So sorry for that interruption. I was both asking and answering a pre-submitted question there, and then punting a couple pre-submitted questions to the next virtual coffee.
Yep, and I can promise no one wants me answering specifics on how to encrypt or anything of that nature. So yeah, definitely for the best. But yeah, focusing on US personal information definitions and the comprehensive privacy laws, we can again see that broader definition that's more inclusive and similar to what we see in the GDPR. Moving down to the European Union, for the GDPR, this definition of personal data is defined the exact same. For organizations considering policies and other considerations of these provisions, in the United States, I believe it's important to be aware specifically of what information is involved in a breach and what data elements a state may include in their breach law. What is a breach in one state may not be considered a breach in another due to those specific data elements that are required to be defined as personal information. Here are a couple takeaways for your program as it relates to analyzing the applicability of privacy laws. To determine the requirements that apply to your organization, consider our first three general questions or determinations of operational footprint, regulated party definitions, and personal information definitions. The purpose of analyzing your operational footprint is to gain more insight on what jurisdictions are in scope for your organization. Remember to consider where you are physically located as well as where you provide products or services. For regulated party definitions, and specifically in the US, organizations should remember that comprehensive state privacy laws will require an analysis that revolves around thresholds and specified exemptions. The exemptions come in the form of entity level and topic level. And also remember that breach notification laws will define the regulated party broadly and not include those exemptions that we talked about in those state comprehensive privacy laws. Regulated party definitions for international jurisdictions often do not include those exemptions, but be aware of those specific exemptions in an article of the law, such as Article 30 of the GDPR, which we reviewed. And as personal information requires analysis for your organization, remember that in the US, breach laws will require that a combination of specified data elements must be shown, while comprehensive state privacy laws will define personal information in a broad manner, similar to what we see in international jurisdictions. Now that we've gone.
Sorry to interrupt, Brandon. I think just to that last slide and kind of thinking about it, and we're starting to, I think, maybe see some themes, right? There are definitely some jurisdictions that have some more stringent requirements or have broader applicability. CCPA for sure, GDPR. So I think the practical effect of this too is that, yes, you may have many jurisdictions that you're going through, you're reviewing, you have to consider, but where do you focus? And it seems to be, especially when you're trying to think about like a simplified policy, or where you will go as far as following like the most stringent requirements. Looking at the most stringent requirements seems to be the best approach. And so, there is kind of a means to an end. It's less and less common that, an organization necessarily, depending on their size and whether they're centralized or decentralized, but does it make sense to have an individual policy by jurisdiction? More and more it's kind of serving everything and saying, how do we craft this to maybe follow the most stringent, because the idea is to have that be as simplified as possible. So I know, just to kind of, bring it together, when our clients are looking through all this information or we're looking over it for them, that's kind of where we're focused on the footprint and what is the most stringent and what should we kind of set that standard to make sure we're kind of following all of the requirements for all the jurisdictions. So I thought I'd just kind of point that out, because it can be a little overwhelming, all of this different information, where should you focus? And that's definitely one of the areas to focus on, is the most stringent.
Yes, and I also think that, considering some of those gold standards, so to speak, obviously the GDPR, but California being the first state, these are the jurisdictions that we tend to see those requirements set the table for other jurisdictions moving forward. Now that we've reviewed the applicability of these privacy laws, we can discuss the commonly regulated concepts often seen, which are breach notifications, data subject access requests, and cross-border transfers. To better aid in our understanding and simplification of these topics, we're going to focus on subtopics which ultimately help with comparing requirements between jurisdictions, harmonizing policies and procedures, possibly with the most stringent if resources allow for your organization, as well as spotting those outliers that require an exemption from company-wide policy. Given that breach notifications are often not an enjoyable topic for organizations, I figured this would be the perfect commonly regulated concept that we start with today. Subtopics that we commonly see within breach notifications are who to notify, the conditions that give rise to the notification of the breach, and the timeline that the specified parties must be notified by. When considering who to notify, a common theme that we see around the world is the data subject whose information was involved in the breach, as well as a governmental entity. We do see that some US states will require notice to consumer credit reporting agencies, oftentimes containing a threshold requirement. For these conditions to notify and mentioning the thresholds, these thresholds in the US are commonly used for notice of a breach to parties other than the data subject, oftentimes the state attorney general and those consumer reporting agencies. The typical numerical condition that we see tied to trigger notice of the breach to these entities other than the data subject are often 500 or 1,000 individuals whose information was involved with the breach. Outside of the US, the analysis or condition to trigger notification is different. This is based on the risk of harm for what the data subject may suffer from the breach that occurred. We also see jurisdictions regulate the timeline in which the breach notice must be made. Common theme around the world is that some language is used to explain that the breach notice must be made quickly. Specifically, we'll see without unreasonable delay or in the most expedient time possible. Some jurisdictions will also include a maximum time to notify that will state that the breach notification must be made no later than X amount of days. Illustrating some of those subtopics that we see here for breach notifications, we can see that all three jurisdictions include those two common categories of recipients of breach notice, that being the data subject and then the governmental entity. We can also see that Colorado includes credit reporting agencies. Moving over to the conditions to notify, looking at the US jurisdictions first, we can see that there is no numerical condition tied to providing notice of a breach to the data subject whose information was involved. However, this is not the case for the Attorney General as well as credit reporting agencies for Colorado. We can see that California sets the line in the sand at more than 500, while Colorado sets the line in the sand at 500 or more. So if it is your lucky day in California and you land at 500 on the dot, it might be time to buy a lottery ticket. However, in Colorado, with this credit reporting agency, we can see that notice to the credit reporting agency must be provided for notice of a breach upon more than 1,000 Colorado residents being involved. I do find the language of these provisions interesting here. Colorado for the state AG says 500 or more, but for credit reporting agencies, they decide to use more than 1,000. It's a small detail, but I do find it interesting to go out of the way to word both of those differently, given the proximity of these provisions within the same law. As we move down to the GDPR, we can see that a numerical condition is not used, but instead risk for the potential harm to the data subject. For the supervisory authority, we can see that only a risk is required, while to notify the data subject, a high risk must be present. You can see that when comparing the US state requirements here to the GDPR, the first notice in an EU jurisdiction, or I should not say first, but the thresholds to raise up, you're going to notify the supervisory authority, and you might not have to notify the data subject. Alternatively, if you have to notify the data subject of a breach, you also are going to have notified the supervisory authority. You can't have a high risk without passing the threshold of just a risk. However, this is the inverse that we see in US states. Data subject can be notified of a breach, but there's no notice to the state attorney general or credit reporting agencies. I tend to believe that this is resource based as to why this inverse sort of situation is set up in the way that it is. Moving over to the timelines to notify for breach notifications, we can see again that common language that requires notice to be made quickly. In the US, we have in the most expedient time possible and without unreasonable delay. In the GDPR, we have without undue delay. Also,
Hey,
there
Brandon, sorry to interrupt. I've got another pre-submitted question that I think is timely for this timelines to notify. How late would you say is too late to provide a breach notification after the discovery of a data breach?
Yeah, so I do hate to give the "it depends" answer, but you can see some fact-intensive language here. There are a number of considerations. Not only is every breach ultimately going to be different, but what might be reasonable to one entity is not going to be reasonable to another. So that is a hard question to put a specific answer on. But I do think that you can get some guidance with these specified periods of time. These are very different for 72 hours that we see under the GDPR or 30 days in Colorado. But I do think that it acts as good guidance for how long is too long.
I think that's a really great point, Brandon. Having the concrete kind of timeframes, rather than some of the subjective language, like without undue delay, that's the kind of stuff you want to avoid carrying over to your policies because it is subjective. So I think you're right on the money there that, these defined periods of time and some of the most stringent ones kind of are a really good guide, guide rails for how you would want to define that period of time within a policy. So it's definitive and there's no subjectivity and room for interpretation as to what that means.
Yep, absolutely. And with some of that fact-intensive language, that Jen had just mentioned, in the U.S., when is a breach reasonably likely to have occurred? What is in the most expedient time possible? What's unreasonable delay? For the GDPR, what's a risk versus a high risk? Or what is without undue delay? Or when is notice feasible within 72 hours? I oftentimes find myself reviewing neighboring sections within the law, guidelines or enforcement actions to get a better idea of what some of these terms may really mean. For example, in Colorado, notice can be delayed consistent with legitimate needs of law enforcement or to determine the scope of the breach and to restore the reasonable integrity of your data system. In the EU, guidelines on personal data breach notifications, these guidelines provide that without undue delay simply means as soon as possible. Personally, I wish that they would, maybe just include as soon as possible within the text itself, but we weren't that lucky, and it ends up being job security for likely everyone watching this. So the vagueness can certainly be difficult to wade through, but it has its benefits as well.
I've got a follow-up pre-submitted question here, Brandon. Are there any U.S. states where organizations should be especially concerned about data breaches? Yeah,
I think that within the U.S., specifically California, this is because the CPRA, the updated version, provided a private right of action for breach. I believe these damages are in the range of $100 to $750, but dealing with all of those on an individual basis would not be a fun process. And then obviously, the damages that are tied to those, I certainly view the breach requirements for California to raise some red flags for organizations, certainly. Organizations that are considering their policies based on these requirements that we're looking at for breaches should be aware of the US states that require notice to credit reporting agencies. This sort of third party may be overlooked, but it's another requirement that's included, and there's a condition that must be met. And oftentimes, providing notice to these governmental entities, it might seem scary or worrisome in a sense. It appears that you're leaving yourself vulnerable coming forward with something that's happened. But you can see that a lot of times, government will get involved to, help with the breach in a way. And so, not only are you required to by law, but I do think that the negative sense or, view with maybe turning yourself in, so to speak, I do think that it can really end up helping your organization by providing notice to those right parties within the right period of time. And in the EU, make sure that you have a process in place to analyze the risks associated with the breach. You might have already done this by conducting a data protection impact assessment, but it's better to be prepared ahead of time, if possible, to maybe smooth out some of the commotion that's associated with a breach. And as Jen had mentioned, consider harmonizing notice requirements with those more stringent conditions where possible. We can see that within the EU, 72 hours is a much shorter period of time than Colorado's 30-day requirement. However, if you have the resources available to your organization, and this notice can be provided with, for all jurisdictions within those most stringent periods of time that we see, not only are you giving yourself a cushion in some of these maybe more lax jurisdictions, but you're harmonizing policy so you can really enforce that centralized information management approach that you may be seeking for your organization. And also, again, remember that in the EU, if you have to notify the data subject, you have to give notice of the breach to the supervisory authority. We cannot have a high risk without passing the threshold of a risk. So some program considerations and general takeaways for breach. Remember that start with listing who must be notified within a specific jurisdiction. Ultimately, this just provides the framework of the subtopics, such as those conditions, thresholds, those timelines, so to speak, that I believe are critical in aiding my understanding of these requirements in a specific jurisdiction. For those conditions to notify, remember that this will often dictate the trigger to provide notice to a specified party. In the US, we will often see the numerical conditions tied to breach notice of recipients other than the data subject. And in international jurisdictions, we often see the trigger condition tied to the severity of the harm to the data subject caused by the breach. And finally, for timelines to notify, all jurisdictions worldwide have some sort of common language to provide notice quickly. Remember to understand that fact-intensive language that we talked about, without unreasonable delay, undue delay, things of that nature, and also be aware of those maximum time periods allowed to notify, stating that breach notice has to be made no later than a specified period of time. You want to ensure that your organization has a process in place that doesn't offend that maximum time period. And also, these maximum time periods can act as when is breach notice too late. We'll move on to data subject requests now. I tend to have the belief that these requests, they greatly vary. There's multiple moving pieces, and it was certainly the most difficult topic for me to generally grasp. But focusing on the subtopics of this area has really made this easier for me to understand. Within data subject request types, we'll see that the request and response type can greatly differ between jurisdictions, but it's important to consider these specific requests that are available because these are often parsed out in specific articles of a law. For the timelines to respond to these requests, common number that we see worldwide is around 30 to 45 days. However, you want to be aware of those jurisdictions that use calendar days, business days, or as we will see, months. And oftentimes jurisdictions will allow that response to the data subject request may be extended. Typically, the jurisdiction will allow an extension that matches that initial time period to respond, but there will also be additional requirements such as the contents of the notice to the data subject that provides the basis for the reasoning of the extension. And finally, one that certainly hits home is the record keeping requirements. I think that it's important to be comfortable with the absence of express retention requirements. We see that these privacy laws are, they're principle based, and so unfortunately, it makes sense that there are not express retention requirements oftentimes. But for those jurisdictions that we do see the express retention requirements, they can often be the lifeline for setting a global retention period. We often see that clients opt to set a 2-year global retention period for these data subject requests with exceptions as needed. So given the absence of express requirements in some jurisdictions, it's important that you might have to consider other sources that provide the basis of retention period for this information.
I think to that point too, Brandon, I think you're very right. The 2-year, I think comes from the 24-month requirement that's under the CCPA for retaining those requests. We also do see, I think, for EU jurisdictions, there's a tendency to maybe retain longer. Still not really seeing a lot of those defined record keeping requirements for data subject access requests, but rather considering for those jurisdictions some of the statutes of limitations, which provide the time frame within which a data subject can file a claim under some of the Privacy Acts. So we do see upwards of 5 years, and some suggestions from DPAs, including the Belgian DPA authority too. So just thought I would make mention of that.
Yep, and oftentimes we'll see some organizations consider it in the same light of processing activities and setting a retention period in consideration of all of those things. And so you might have to look in some non-traditional spots when we're considering from a retention schedule standpoint, but just know that that's common for everyone. It's not just you. And here we have some of those specific provisions as they relate to data subject requests. Starting with the request types column, we can see that these greatly vary. However, I did not include all request types for California. We would have been a couple slides there trying to get everyone out of here on time, but these are very limited in Hong Kong, and the terms that are used are not consistent. California's right to know, it really is just a right to access. So having an understanding of the specifics of what each request type is and what can be made in a jurisdiction can be useful. Moving over to the timelines to respond, we can see that all jurisdictions fall within that common 30 to 45 day response time that we typically see. However, you can see that California has an additional requirement that's not provided for in other jurisdictions to confirm receipt of the request. This is within 10 business days, while organizations are required to respond with the action taken within 45 calendar days after receipt of the request. Again, this is one of those scenarios where they did not make it easy for us, but having an understanding of harmonizing those response periods when possible and calculating that legal response time, it is the difference between doing what you're required to and not doing what you're required to. And so those little details can greatly impact your organization. And we see within the GDPR a 1 month. Luckily for everyone, myself included, I didn't include the details of that 1 month, but I can say it's very dense. And so that 1 month, it's not your traditional maybe 30 days. I saw an example that 1 month could be up to 36 days if certain things fall right in line. And so being able to calculate these and consider harmonizing those with your company policies where possible is obviously beneficial, but it's important to still be aware of those nitty-gritty specifics because they can have a large impact as they relate to these requests. Moving over to the extension column, we can see that within the US, both states here have a 45-day extension, matching that initial 45-day period. This is common for all states in the US except for Iowa, but you can see that having some of that regularity that one state might just be following another, other than Iowa, it can help in your determination of those policies. Obviously, if some of these tend to be viewed as outliers or too long. For the EU, 2 more months. This is a much more lax requirement, which is not traditional of what we see. Obviously, so far for what I've shown, these EU requirements are more stringent, and so to see them back off from the perspective of extension response time, I do find that interesting as well. And in Hong Kong, no extension is allowed. Then as we move over to the record keeping requirements for these jurisdictions, as Jen had mentioned, the 2-year, at least 24 months that's provided for in California and Colorado, sort of that lifeline for the global retention period. Then allowing for exceptions based on what your organization needs. We can see that these are 2 years, but with Hong Kong at 4 years and no requirement for the EU, you're going to have to find basis for your retention period. So business is going to need to balance their business needs and legal risk to determine that appropriate retention period. And more specifically, how long do I need to justify this practice? And as Jen had mentioned, applicable statutes of limitation can be very valuable for this consideration. For an organization considering policies based on the provisions that we see, they may consider harmonizing response to access and correct. Within these provisions, the most stringent for timeline to respond being the European Union requirement for 1 month. But again, remember that 1 month can greatly vary. Harmonized company policy for extension, 45 days would be the most stringent here. However, no extension is allowed in Hong Kong. And for record keeping, I would imagine that most clients would go with that 2-year, a 4-year exception for Hong Kong, given that express retention requirement, and making those risk and business need considerations as they relate to your organization. General program considerations as they relate to data subject requests include the request types that can be made in each jurisdiction. It's important to be aware of those specifics because they're far from uniform as to how they're defined and what is even provided to a data subject. For response deadlines, know how to calculate that legal response time. Seeing calendar days, business days, months can certainly make this more difficult, but this must be done in order to harmonize your company policy as it relates to these data subject requests. And finally, for record keeping, most organizations are going to start with that 2-year exception, 2-year global retention with exceptions as needed. This is in line with those express retention requirements in California and Colorado. But for those jurisdictions where an express retention requirement is absent, remember to consider statutes of limitations, and you may also be able to reference decisions in case law to provide your organization with more guidance on the topic. And our last commonly regulated concept that we will discuss today is cross-border transfers. Cross-border transfers are critical for organizations with a global footprint. These transfers allow for a centralized retention approach for where the information is stored. This is often desired by clients. It's easier to not have these storage sites all around. The 2 categories of cross-border transfer activities that I like to think to simplify in my mind is the first being methods that the transfer can be done. This is things such as adequacy decisions, standard contractual clauses, and frameworks. The other category, and what we will focus on here today, is those requirements that must be completed before information can be transferred, and specifically consideration of localization requirements, conducting transfer impact assessments, and providing notice of the possibility or of the transfer to the data subject. For localization requirements, these will specify that certain types of information are required to be kept within a certain jurisdiction. These requirements are very rare and they may be overlooked due to how uncommon localization requirements are, and sort of getting a gung-ho on just meeting the requirements of a cross-border transfer.
While they're uncommon, though, the majority of jurisdictions that have these are pretty impactful, is what, talking to clients has revealed. Something that I've thought about is how the localization requirements can be a big hurdle to organizations attempting to more centralize a centralized approach to managing their systems and applications from a RIM perspective. And those organizations that are doing that are having to selectively kind of decentralize parts of their systems to comply with these initiatives. And that's making it harder for them to ensure defensible disposition of their information in line with their records retention schedules and RIM policies. So I think it's fair to say that these laws are impacting, the RIM programs that are, oftentimes more mature in trying to holistically and manage their information in a more centralized way. And so, though they're uncommon, they are impactful.
Yep, certainly. And yeah, we see those requirements present in a number of jurisdictions. Just a couple examples: Russia, China, and as we're about to see shortly, Vietnam. And so they are rare, but the impact that they have to your RIM and privacy programs is certainly significant, to say the least.
Yeah.
For transfer impact assessments, these will require controllers to consider the risk associated with the transfer of personal information to another country. The specific requirements or findings with these impact assessments can greatly differ between jurisdictions, so I believe it's important to avoid a one-size-fits-all approach. And the last subtopic for these cross-border transfers is notice. It's common that the data subject has to be provided some sort of notice of the even possibility of a transfer. These notice requirements are sometimes provided for under sections that you would not normally consider. They relate to obviously the cross-border transfer of information, but these may be found under notice section. So it's important to sort of have that cross-reference identification and ability when you're reviewing these laws. And similar to the findings of those transfer impact assessments, the details of what the data subject, or the content, I should say, of that notice greatly differ. So again, important to avoid that one-size-fits-all approach. Here are some of those specific provisions for cross-border transfers. The United States does not have laws that restrict the transfer of personal information outside of the country. However, you still need to be aware of requirements that relate to the transfer of information inside the United States. An example of this is the EU-US Data Privacy Framework. Looking at the localization requirements, as we had just discussed, these are uncommon, but quite impactful. I believe that when you're considering these localization requirements, start with that general analysis again. Who does this regulate and what information is regulated? They're very related, and it's difficult sometimes to wrap your head around why these are under separate provisions of law. But with that said, just another step in the analysis that we have. For impact assessments, you can see that these are often recommended or required, but as I had mentioned, specific details, findings, and contents greatly differ. So this could be another subtopic that your organization may consider moving along. And finally, for the notice to transfer, again, common to require some sort of notice to the data subject of the possibility of their information, but the specifics of the topic and even just at the content level greatly varied by jurisdiction. You can see that within the GDPR, the intent to transfer, whether this is to a jurisdiction where an adequacy decision has been published, or appropriate safeguards if there is no adequacy decision. Alternatively, in Quebec, you simply have to communicate that their information could be transferred outside of Quebec. And moving down to Vietnam, much more stringent, there's a requirement for consent of the data subject. And so, yeah, this is really hitting home, I believe, with those specifics of the details that can greatly vary as it relates to the content and what must be communicated for notice of the possibility of transfer. And a couple takeaways for your organization. For localization requirements, remember to research and analyze if these requirements exist for where your operational footprint lines up. If these requirements are discovered, go through that same analysis, regulated party and information type. For transfer impact assessments and notice, I think it's important to start with the simple question of, is a transfer impact assessment required, or is notice required before transfer? This ultimately sets up that table, that framework, so that you can develop those subtopics and tailor some of those requirements to what helps your understanding as well as your organization. So with all the information that we've discussed today, I hope you've acquired some valuable knowledge as it relates to your organization. Obviously, these privacy laws are very dense, but begin by assessing your operational reach. Your operational footprint can help with identifying the privacy laws that you need to review. Start with that regulated party and personal information review. And once you have those in-scope jurisdictions based on thresholds and other considerations, you can start reviewing commonly regulated concepts that we see, such as those that we discussed today: breach, cross-border transfers, data subject request. By identifying common themes that you see as well as outliers, an organization has a better understanding and information to make the best decision for what works for them, harmonizing policies where possible and creating those exceptions where needed. And a couple valuable resources that often help with my understanding. Don't overlook the definition section of a law. It might not be the most fun, it might not be in all the different colors, but it can be very useful in your understanding. Also, government websites, they will break down these requirements into smaller chunks. They'll use plain language, and it's just language that's used for the common person. This also allows for a general understanding of these laws in a very short period of time. And finally, consult guidelines. They'll provide descriptions or general examples that might help you in hashing out some of that fact-intensive language.
We had a couple other pre-submitted questions that I don't think we're going to have a chance to get to, and they relate to this bringing it together topic, purging of data in the context of data privacy programs of multinational companies. We had another one as well that related to driving ownership and how to simplify complex processes. I think we're going to have to punt those to the next virtual coffee because we're just out of time. We've got about a minute left. And so look forward to that and explaining some of those more in the weeds details about it. So Brandon, if you want to advance last couple slides.
Yep. Yeah, thank you. Yeah, everyone for joining us today. My email is here if you want to reach out with any questions or comments or just continue the discussion. You can also find my LinkedIn here.
And then, sorry, Brandon. Stay tuned because we'll be sending out the details soon for our follow-up continuation privacy virtual coffee in March. As Jen mentioned, we plan to get even more in the weeds with privacy and talk about how organizations are implementing these privacy rules and policies, processes, and their impact on records retention schedules. And then also, as you can see on the screen, our very own Jake Naylor from Zazio Consulting is joining frequent guest of Virtual Coffee, Zazio's Warren Bean, to discuss the anatomy of a legal citation. They're going to take you behind the scenes on what goes into maintaining and publishing legal record keeping research so that it can be easily linked to retention schedules and interpreted. Topics are going to include where citations come from, how they're normalized, how Zazio deals with the many hurdles that arise in the process. The webinar is Thursday, February 15th at 9 a.m. Mountain Time. So check out the events page at the Zazio website for more details. Thanks, Brandon, for all of this information and your knowledge with this. It was great. Thanks to everyone for joining us, and we'll look forward to seeing everyone at our next virtual coffee in March.
Thank you, everybody.
Thank you, everyone.